It's not just what they did, but also how they did it. San Antonio police arrested a couple who made their way inside about half a dozen storage units.
San Antonio police arrested 46-year-old Johnny Galvan and 42-year-old Natalie Rodriguez, who they say had been stealing their
calling 2025 C.
Welcome to one of the most layered plea hearings you'll ever witness. Today, 46-year-old Johnny Galvan is facing the kind of charges that can bury someone in the system. A first-degree felony drug case and a burglary charge, both carrying serious time. But it's not just the charges that make this case fascinating. It's how it all plays out in the courtroom. We've got waived enhancements, concurrent sentences, and a surprising criminal method that will make you think twice about how secure your property really is. Stick around. The ending is going to hit harder than you expect.
R006113, State versus Johnny Galvan. Could I have parties announced for the record?
Jason Garahan for the state. David A. Garcia, attorney for Johnny Galvan.
And are you Johnny Galvan?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge. Judge, sorry to interrupt, but I believe there's two cases.
There are two? Okay,
Sure.
thank you. Oh, there is. Also, the court is calling 2025 CR 006603. And in that cause number, counsel, have you received all the discovery as well?
Yes, Your Honor.
Then in each cause number, the court will find that the state is in compliance with discovery. In each cause number, counsel, did you review the true bill of indictment with your client?
Yes, Judge.
And Mr. Galvan, did you review the true bill of indictment with your attorney? Did you understand it? And each cause number, counsel, do you waive the reading of the indictment?
We do, Judge.
State in the cause number ending in 13, which is the drug case, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 2, proceeding on count 1 alone, and we're also waiving the enhancement paragraphs.
No, Judge, Your Honor.
All right, and in the cause number ending in 03, the burglary of the building, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraphs.
No objection.
All right, Mr. Galvan, cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 13, the state is proceeding on the count that is the manufacturing delivery of a controlled substance penalty group 1, 4,200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to 10,000.
Shyam, when you hear 5 to 99 years or life for one count, and up to 2 years for another, it puts the seriousness of these charges into stark perspective. The judge isn't just rattling off numbers, she's outlining the full scope of the law and the possible consequences if this plea bargain isn't followed. That part about being able to withdraw the plea, that's a built-in protection for defendants, but here's the kicker. In reality, very few ever do. Why? Because once you're standing in court with a deal on the table, the pressure to just say yes is immense.
$1,000 fine. In the cause number with the burglary of the building, the range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have plea bargain agreements with the state in each of these cause numbers, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
He does, and I do.
In each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Galvan, in each of the cause numbers, has anyone threatened you, coerced you, or forced you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it and sign it? I'm sorry, and each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
And the cause number involving the burglary of the building, according to the plea, 145 days in the Bear County Jail under 1244. There's a $2,000 fine. The cases will run concurrently and also concurrently with 2019 CR 13796. And the other cause number involving the drug case, according to the plea, punishment is to be assessed at 5 years in the prison. The state is proceeding on count 1. There's a $2,000 fine. There are no applications.
This is where defense attorneys earn their keep. The magic phrase here is run concurrently. That means Johnny won't be stacking one sentence on top of another. Instead, he serves them at the same time. 5 years suddenly sounds a lot better than a potential decade plus. And notice how both the 2025 charges are linked to an older 2019 case. That tells us this isn't Johnny's first run-in with the law. In criminal court, prior history can be a huge factor in sentencing, even if the judge isn't spelling it out in plain English.
They were run concurrent with 2025 CR 006603 and 2019 CR 13796. Did you understand that to be the plea? Defense, is that the plea in each of the cause numbers?
It is, Judge.
State,
Yes, Your Honor.
did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
Filed but not heard on.
Then in cause number 2025 CR 006603, the burglary of the building, how do you plead? Guilty, not guilty, or no contest? And in the cause number ending in 2025 CR 006113, how do you plead? Guilty, not guilty, or no contest? State, in each of the cause numbers, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State Exhibit number 1 with all the statements in each case.
You reviewed stage 1 and all the attachments in both cases that we have.
In each cause number, did you review the waiver relations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, and cause number 2025 CR 006113, court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. This is run concurrent with 2025 CR 006603 and 2019 CR 13796, and the court will request the therapeutic community. And cause number 2025 CR 006603, court is going to sentence you to 145 days in the Bear County Jail under 1244. Give you credit for any time served. This is run concurrent with 2025 CR 006113, 2019 CR 13796. There's to be.
That no contact order with Natalie Rodriguez might sound like a throwaway line, but it's actually significant. When crimes are committed in partnership, keeping the parties apart is crucial, not just for public safety, but to prevent coordinated stories or retaliation against witnesses. Judges know that old alliances can reignite criminal behavior, so they cut those ties legally. Violate this, and Johnny could find himself back in front of the same judge, and this time without the benefit of a plea bargain. It's one of those orders that seems simple until it's broken.
No contact with Natalie Rodriguez. All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, the other cause number, he's not currently on probation, is he?
No.
All right.
Oh, is that a rule?
I think that's the 2019. All right, good luck to you. Thank you.
Thanks, Jeff.
Thank you, Judge.
Thank you.
Thank you.
It's not just what they did, but also how they did it. San Antonio police arrested a couple who made their way inside about a half a dozen storage units. Our Katrina Weber shows us why the crimes most likely took the victims by surprise.
With bars at the entrance and cameras all around, this public storage appears to have taken steps to make things secure. Yet San Antonio police arrested 46-year-old Johnny Galvan and 42-year-old Natalie Rodriguez, who they say had been stealing there repeatedly. They've linked both to about a half dozen crimes at the business on Ingram Road near Highway 151. Police say Galvan and Rodriguez technically were customers there with their own storage unit, but found an odd way to get inside those of others. While it may not have been this easy to do, police say the couple was able to get into other people's storage units by cutting a hole in the wall from their own and then helping themselves to whatever's inside. I left a message for Public Storage's corporate office in California, hoping to find out more, including what was taken. Hi, Greta. My name is Katrina Weber. I'm with KSAT 12 News. A police report says the couple cut right through the wall, breaking into other units after hours. It says surveillance video helped police identify them. Then they caught them this weekend during a traffic stop. Police say Galvan told them he stole out of necessity because he was out of...
To wrap it up, Johnny Galvan walks out of this hearing with 5 years for the drug case and 145 days for burglary, both running concurrently, plus a strict no-contact order with his co-defendant. The crimes: cutting through walls from his own storage unit into others, a low-tech but high-impact burglary method. It's a sentence that balances punishment with efficiency, but it leaves plenty of questions about what happens when he gets out. What do you think? Fair outcome or too light? Drop your thoughts in the comments, hit that like button, and subscribe for more courtroom breakdowns that take you inside the real drama.